Good evening and welcome to the second day's edition in the month of June, the 10th of June, to my new sum up of cases of some importance in the High Court of Telangana. Start off with a news story of Justice B. Vijay Sen Reddy, who refused to grant an interim direction with regards to a writ petition filed by the Sri Gomunendra Swami Trust, represented by Vedantam Anantarama Sharma, who would complain that the government and its agencies were illegally and without the authority of law interfering with a temple premises and the nearby Goshala near the temple of Uma Maheshwari temple at Yapra. The petitioner would also contend, notwithstanding the suit and civil litigation, the government was high-handedly marching its way through and ensuring demolition of areas around the temple and the Goshala. The judge said an interim order of the nature sought would have to await instructions from the government by the government leader and adjourn the matter by a week. Justice Nanda of the Telangana High Court rejected a writ plea filed by various persons such as Nam Hotels, AMN Hotels, KS Business Consultants, MN Infrastructures, and Arti Comtech and other individuals. They came before the High Court challenging the power of Kotak Mahindra Bank in initiating measures against them and their lands under the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interests Act, for short the SARFAESI Act. The SARFAESI Act, for the uninitiated, is an enactment where when there are loans not paid to banks over a certain specified sum, they move this tribunal that adjudicates the matter. The judge reasoned that the matter will have to go before an appropriate tribunal and that the petitioners could not have maintained a writ petition before the High Court. While it was the case of the petitioners that these lands were assigned to them, they were land sealing lands assigned to these persons, and therefore assigned lands could not have been attached under the SARFAESI Act. Justice Nanda rejected the legal argument, saying that this is an argument they will have to take before the appropriate forum, and dismissed the writ petition. A two-judge bench of the Telangana High Court, Justice Mautshumi Bhattacharya and Justice Madhusudan Rao, took on file a habeas corpus writ petition about a 15-year-old girl. The parents of the girl would come before the High Court for production of the girl child who is their daughter and who has been missing. According to the police, the child had gone on her own volition to a person that they knew in the family, now residing at Suryapet. Their case is that since the child had gone on her own volition, a habeas corpus could be suspect. The panel, however, said that she is a minor child and her whereabouts will have to be traced. The petitioner also pointed out, she being a minor child, her volition would be of no referral point. The bench granted time to the police to find out the whereabouts of the child and produce her before the court. Justice S. Nanda of the Telangana High Court rejected petitions filed by the parents-in-law and the sister-in-law of a lady who claims to be a victim for domestic violence. Her case before the appropriator authority is that she suffered acts of domestic violence in the hands of her husband, her parents-in-law and her sister-in-law. The parents-in-law and the sister-in-law are in a writ petition before the High Court seeking to quash the criminal complaint under the DVC Act, contending inter alia that the allegations were not against them and therefore no overt acts were attributed to them, and therefore the petition should be quashed. Justice Nanda disagreed. She said that a DVC matter is a matter where questions of fact and law are involved. A woman is entitled to protection under the DVC Act. The court in charge of the investigation and the trial of the matter will look into the matter, and at the end of the trial will come to a conclusion as to whether the parents-in-law are guilty or not guilty of the offences they are being tried for. The parents-in-law and the sister-in-law also made an attempt to argue that the wife and the husband lived separately ever since they got married, and therefore there was no connect between the two families. This argument also, the judge said, was a matter of fact and will have to be investigated and will have to come out in the course of a trial. The judge accordingly dismissed the DVC quash petition filed by the parents-in-law and the sister-in-law. To many of you who are hearing me would be may particularly note that names of persons are not being mentioned in this case and in the habeas corpus matter. The reason for that is in the later, it is a policy not to mention the name of a victim in a matter of this kind, and in the earlier, because it was a minor child, the identity of the person is not being stated. Justice B. Vijay Sen Reddy of the Telangana High Court directed the state government, civic authorities to ensure that they do not dump any material in 73 acres and thereabouts of disputed land at Gutla Begumpet. The dispute is between two private parties, which is now up in a writ appeal before a division bench. Bakhtiar Khan, the successful person before a single judge, came before in this round of litigation complaining that in spite of an order of status quo by the High Court, the government was interfering, entering into the lands of 73 odd acres and dumping material. Mr. Bakhtiar Khan and the named respondent, Mr. Raunak Khan, are inheritors of the property and purchasers, some of which is Paiga property, prime property in Gutla Begumpet. Their contention is that the Hydra authorities had put up a board stating that because of violation of a status quo order, they had put up the board. It was the case of one of the counsels before the court that the government nor Hydra are executors of the High Court order, and therefore they could not execute the order of status quo of the High Court by violating it and dumping material in their private land. The judge granted an interim order and directed the civic authorities to come up with their defense through a counter affidavit. This much for today. See you at another edition tomorrow. Yet again, acknowledgements to Mani Sahib for reaching out and helping me reach out to all of you. Good day. Bye-bye.